Thanks very much. It's great to be here, especially and particularly thanks to Joanna, who's been so supportive of my work for so long. What I really want to talk about today is how the International Criminal Court in particular negotiates justice and how its decision making and the decision making in particular that exists within the court or that's done within the court affects and explains and can help us explain the ultimate effects that the court has on peace and conflict processes. So before I get into that, I'll just give a brief overview of what I'm going to talk about. The first thing I want to talk about is the ICC's impacts. I won't go over at all really what those impacts are. I think they're pretty well established within this so-called peace versus justice debate, but I want to look at three things that the literature doesn't really tell us about what the ICC's impacts are. Then I'm going to suggest to you what my puzzle is, or what I'm really looking at, which can be kind of summarized by this question: not what impacts does the ICC have, but why does the ICC actually have the impacts that it does. Then I'm going to look at institutions in particular, and how international organizations have institutional interests, and how they end up picking winners versus losers when they decide to intervene, and what that looks like. And then I'm going to explain how this exists within the International Criminal Court, which I'm going to present as an insecure and anxious institution. And through that, I want to show that it negotiates its own institutional interests with the interests of the political actors upon which it depends. And to show this, I'm going to look at two cases very briefly, but show how this works in two cases that I've been working on the last couple of years, which are Libya and northern Uganda. So the International Criminal Court and impact. Again, generally speaking, this is dealt with in the peace versus justice debate. I would suggest that there's three issues that the literature on the subject doesn't really tell us. And these are the things that are guiding my research, or have been guiding my research for the last little while. The first thing is that the literature doesn't tell us whether how the ICC intervenes matters. Does it matter whether, in particular, there's a United Nations Security Council referral of a situation, or a government self-refers itself? Does it matter? Does it make any difference to the kinds of impacts we'll ultimately see? Secondly, does it matter who the ICC targets and who the ICC doesn't target? Generally speaking, if you look at the literature, it'll suggest, for example, that rebels like Joseph Kony of the Lord's Resistance Army will respond to ICC arrest warrants in the exact same way that Muammar Gaddafi will, despite the fact that he was a head of state in Libya for 40 years. There's kind of an assumption that actors will act the same, despite the fact that, again, one is a state-based actor and one is a non-state-based actor. So does this matter in terms of our analysis of the impacts of the ICC? And thirdly, how does who the ICC ends up targeting, how does that legitimate or delegitimize particular types of actors, and then how do they respond, and how does this ultimately affect the way that they engage or not engage perhaps in a peace process or an effort to resolve the conflict? So my puzzle can basically be summarized through this table, and what I'm particularly interested in is the bright red rows and the two yellow rows. So the bright red rows show Uganda, DRC, the Central African Republic, and Mali, which are self-referrals. And what you'll notice with this table is that in every single instance where there has been a self-referral, the only targets of the International Criminal Court have been rebels, so non-state actors. Conversely, if you look at the yellow rows, Darfur and Libya, those are situations where the United Nations Security Council referred the situation to the ICC. What you'll see there is the opposite pattern, that the ICC tends to target government actors. In fact, there's a digit 2 in the non-state actors for Darfur, but that actually pertains to two individuals who were summoned to the ICC and later indicted for an attack on peacekeepers. So if you kind of take that away for a second and imagine that the intervention by the ICC is about the conflict, you can even say that should actually be a 0 rather than a 2, because that's an isolated event from the wider conflict and alleged genocide there. Now there's three explanations that are possible for what this chart tells us. The first is that this is an accurate portrayal of the distribution of atrocities and international crimes in these situations. In that instance, the ICC is absolutely right, and every time that a government has self-referred itself to the ICC, the only people who are committing mass atrocities are, in fact, non-state actors, so the rebels. And whenever the United Nations Security Council refers a situation, the reality is that in Darfur and Libya, the only people who are committing crimes are government actors. The second possibility is that this is not true, this is an inaccurate portrayal, and what the ICC is doing is simply doing the bidding of the states and the political actors that are referring situations to the ICC. So in this case, the ICC is in the hands of Uganda, and it's in the hands of the United Nations Security Council, depending on the referral type. And then the third possibility, which I think is the most likely, is that this is an inaccurate portrayal of the distribution of criminality in these situations, but there's something more complicated going on. And what I'm going to suggest is what's happening is this negotiation of institutional interests of the ICC with the interests of the actors that end up referring situations to the court. Now, to do that, I think we need to get a little bit of a better understanding of international organizations themselves. And in this regard, the ICC, like other international organizations, I think have to be understood as having agency. They're agents in their own right. And I'm particularly influenced by the work of Michael Barnett and his seminal book called Eyewitness to Genocide, which if you haven't had a chance to read, I certainly encourage you to do so. But briefly, what his situation was that he was a visiting professional at the United Nations when the genocide in Rwanda broke out. And a couple of years later, he was reflecting and writing this book to try to explain why the United Nations had failed to act to stop the genocide in Rwanda. And rather than say, is this moral failure, or they didn't know enough, or they didn't care enough, or didn't have the resources, what Barnett is trying to tell us is that the United Nations, as an international organization, can be described as a kind of church with believers within it. And in this very early post-Cold War world, those believers wanted to protect the interests of the United Nations by determining which situations the UN would intervene in and which it wouldn't. And those were described as winners and losers. So in this instance, Barnett would describe the intervening in the genocide in Rwanda as basically a loser. So these decisions would be made to protect the interest, the institutional interest of the United Nations. And I would suggest that the ICC does the exact same thing, and that it perhaps is even more, this situation of institutional interest and how it picks them is probably even more, is heightened in a sense, because the ICC is a very strange body in the sense that it is both an international organization and a criminal court at the same time. And so it sits very precariously, as many other people have noted, between being a political institution and having to do politics as an international organization and having to do law. So how should we understand where the ICC kind of got these institutional interests before I actually identify them and how they're expressed? Well, I think we need to recognize, first of all, that the ICC was born into a very insecure world, and that it is a very insecure institution. That has been changing slowly as it's matured, as it's learned from certain other interventions, and it's learned from its past, perhaps, mistakes. But it certainly was born in a world of insecurity. If you ask the first judges, and I heard President Song, who's the first president of the ICC, I heard him say, for example, that when he was elected, he didn't believe that the project, so the whole of the International Criminal Court, would exist within 10 years, and that his fellow judges felt the same. They simply didn't think it could survive, the harshness of global politics. And if you look at the first cases, judges were basically asking prosecutors to give us our first tadich, just give us something. This evokes the first case at the International Criminal Tribunal for the former Yugoslavia, where they got this one small fry tadich, but then it's seen as having created this momentum for the ICTY to kind of have a life of its own. And judges were very much saying, just give us something, which I'll come back to. That ended up being northern Uganda. And at the same time, of course, if you look at the early years of the International Criminal Court, the superpower of the world, the United States, was pursuing very proactive and aggressive anti-ICC policies to try and undermine and isolate the court. So within this context, again, you can imagine the decisions that the ICC makes in terms of where to intervene and who to go after have to kind of align with this idea of picking winners and avoiding losers, and in a sense picking strategies for itself that would reaffirm its value and make it feel, in a sense, less insecure. So what are these institutional interests? I would argue that there are three primary key institutional interests of the ICC. The first is to get cooperation in order to get evidence, so whether it be witness testimony or documentation or whatever it may be. The second is cooperation for enforcement, so the enforcement of any arrest warrants it issues. Oftentimes you'll see kind of cooperation lumped together under this kind of sole heading. I don't think that that accurately portrays what is actually going on, because the political actors that are involved in cooperation for evidence versus cooperation for enforcement are likely to be different, and the political calculus of actors that would be able to do one versus the other are also very different. And the third institutional interest that I think exists within the International Criminal Court is this reputational interest, so this desire to be seen as being relevant and therefore legitimate and in fact useful to the international community. And I would suggest that these interests are in a sense, again, negotiated against the interests of those states or those political actors that refer situations to the ICC. Those interests of those actors are pretty clear. We could guess them, the ICC guesses them in the same way. If the United Nations Security Council refers Libya to the ICC, it's clear they want the ICC to go after Muammar Gaddafi because that's who they're going after. In the case of Uganda, it's clear they want them to go after the Lord's Resistance Army. Now, this negotiation of interests, however, I would argue is what produces selectivity, and the fact that what generally seems to happen when the ICC intervenes, as that chart showed, is that it only really goes after one side of a conflict and rarely both. However, this is not the way that the ICC sees it, at least not the Office of the Prosecutor. And this is a response that I got from Deputy Prosecutor James Stewart. Happens to be a very nice Canadian, a very thoughtful person. This was in the early days of him being Deputy Prosecutor. I think he wouldn't say that necessarily now because it was very forthright. But this is what he was saying in response to allegations that the ICC was very selectively targeting only one side of post-election violence in Côte d'Ivoire. So he says, the Chief Prosecutor, for example in the case of Côte d'Ivoire, has always made it clear that she intends to look at all sides of the conflict. Sometimes you just can't do everything at once. You have to make a choice between action and paralysis and between pragmatism and ideals. And I think if you choose pragmatic action, you really shouldn't be criticized. But in the end, I suppose history will tell us whether or not the Office of the Prosecutor has acted appropriately. And what he's basically saying in this instance is or what he's describing is actually a prosecutorial strategy of selectivity. And he's being very forthright. And he's saying that we can't actually pursue all sides. It might be the ideal situation. We understand it's the ideal situation. We understand that both sides of a conflict or all sides of a conflict tend to perpetrate mass atrocities. But if we go after all of them, we won't get any justice. So kind of to change up the words of Barack Obama, this argument basically says that there's a pragmatic course of action and that can't allow perfect justice to be the enemy of any justice. Now, what does this look like in practice? So let me look at two cases, Northern Uganda and Libya. Northern Uganda was, of course, the first situation that was referred to the ICC. And prior to this, looking at in the Office of the Prosecutor, they were very concerned about which situation to look at first and which situation to intervene in first. Interestingly enough, Luis Moreno Ocampo, the first Chief Prosecutor of the ICC, actually preferred the Democratic Republic of Congo. And there was a running joke within the Office of the Prosecutor which told him, don't be another Che Guevara. Luis Moreno Ocampo is Argentinian, and this was basically a joke along the lines of Che Guevara, because Che Guevara had actually ended up in the DRC attempting to create a revolution and had failed in doing so and got nowhere. So they were saying, don't just go into the DRC, don't just go there, because you'll ultimately fail. But what he really wanted, and what the Office of the Prosecutor truly wanted in their first case, was a situation that would prove that the ICC was one more than a paper tiger, so that it had some bite and some relevancy, and also to show that it would be politically astute. So in particular, what that meant was that it wouldn't run roughshod with state sovereignty. So they sought a self-referral rather than intervening on their own volition through other means. And this, of course, would act to serve their institutional interest in terms of reputation and relevance on the international stage. And they also had to find a place where the narrative fit, where they could find somebody or someone or some type of actors that were condemned by a broader international narrative. Fast forward a couple of months and they're presented with this case of northern Uganda where the Lord's Resistance again is condemned through this narrative of being, you know, this epitome of all evil. Museveni, the president of Uganda, essentially negotiates with Luis Moreno Ocampo. They end up at a press conference in London very infamously announcing the self-referral, which gives this indication of severe bias towards the government of Uganda, but again this fit perfectly with the narrative. So eventually what happens, which is quite predictable in this instance, given that Museveni was there at the press conference, is that only the Lord's Resistance Army, 5 individuals from the Lord's Resistance Army, are targeted by the ICC. This is a quote from a senior official at the ICC who was there when the decision to target the LRA was made. Quote, "At this moment, the prosecutor is trapped. Yes, it is a referral of a situation, but if he wants the support of the country, information, documentation, then he needs to operate in the country. You say, quote, we are going to look at UPDF, UPDF being the Ugandan military, allegations against the UPDF, end quote. What kind of document do you have? That's the issue. How are you going to be able to make your case against the country, against the power, against the head of state who actually is able to block all the documents so that you can't have any information about these cases? One of the main things for international criminal justice is to have support of the states. If Moreno Ocampo said, I will investigate not only LRA but UPDF, he will not have the support from Uganda. All of what you need to investigate, you will not get. So this helps us to explain, again, this dependency on cooperation that the O2P that the Office of the Prosecutor understood that it needed from the government of Uganda, and I think helps us to understand why the ICC ended up only prosecuting, or only seeking to prosecute members of the Lord's Resistance Army. I would also argue that this is where the effects of the ICC on peace, conflict, and indeed justice processes begin. In the end, it clearly legitimated the government, because the government was not targeted, so they ended up being seen as the good side of the war, and delegitimized the LRA, once again castigating them not only as evil now, but in fact as criminal. And this was a great manipulation, and I would say even a great game, in a sense, by President Yoweri Museveni of Uganda. He now plays both sides. I don't think you could find a more virulent critic of the International Criminal Court than Yoweri Museveni. And yet he allows for cooperation with the ICC on the territory of Uganda. And the reason he does this is because he understands that the ICC is dependent on him for cooperation. And he's done this brilliant most recently. If you've been following, there's about 2 years ago, the only member of the LRA to ever be in the custody of the ICC was sent to the International Criminal Court. His name is Dominic Ongwen. He is one of the 5 individuals who were indicted by the ICC. And because of how vociferously anti-ICC Museveni was, I think a lot of people thought, well, he certainly wouldn't give up custody of Dominic Ongwen to the court. This is too much of a win for the ICC. It'll show that it's relevant. But I think Museveni really understood something, that if Ongwen was sent to the ICC, then the ICC would continue to need the cooperation of the government of Uganda for cooperation to build, to get additional evidence for Ongwen, to do outreach programs in northern Uganda, and so on and so forth. And as long as that dependency on cooperation exists, there is no way, as the quote that I read out suggests, there's no way that the UPDF, the Ugandan military, or any government officials will ever be targeted by the court. So in a sense, that dependency on cooperation assures Museveni's impunity. The second case is Libya. I think it's interesting. Libya was particularly interesting because it kind of came out of nowhere. There was no sense that the International Criminal Court would intervene in the Arab world in particular. They weren't particularly prepared. Yet still there's this referral from the United Nations Security Council in the wake of unrest in Libya in February 2011. There's certainly a sense of celebration within the Office of the Prosecutor, and the International Criminal Court is very eager at that moment to, one, capture the narrative condemning Gaddafi, two, to be seen as being useful to the United Nations Security Council, and to hopefully, if it can, have a positive impact on the conflict itself. And again, I'll quote a number of people here, but quoting a senior member of the Office of the Prosecutor, we, quote, focused on what we saw as an incredible step of a unanimous referral from the United Nations Security Council. It felt like a legitimizing step. So again, you get the sense of them being eager, the Office of the Prosecutor being eager because it suggested this relevancy in international politics. Yet despite this, if you actually look at the text of the referral of Resolution 1970, which referred the situation in Libya to the ICC, it's heavily, heavily politicized on a number of counts. The most controversial probably is that the referral prevents the International Criminal Court from investigating or prosecuting any citizens of states that aren't members of the ICC. This is seen as a violation of basic principles of law and international law as well. It restricts the court to investigating only crimes or only events that occurred after the 15th of February 2011, which cuts out this period of Gaddafi's rehabilitation. It cuts out the period where intelligence agencies, particularly in the UK, but also in the United States, were collaborating with the Gaddafi regime over things like extraordinary renditions in the global war on terror and so on and so forth. It kind of cuts that out of the narrative of the conflict. It provided no funding to the International Criminal Court for its activities, and it included a reference to Article 16 of the Rome Statute, which may not be that controversial, but Article 16 allows the UN Security Council to, in a sense, put a halt to any investigation or prosecution by the court if it's deemed to be a threat to international peace and security for a year, renewable yearly. Yet, again, to quote somebody from the Office of the Prosecutor, there was few concerns. Instead, to complain about how politicized this referral was to quote, quote, like getting a great gift on your birthday and then complaining about the wrapping paper. I asked somebody else, and I guess they were prepared with very flowery responses, because someone else said it would be like getting 24 roses and complaining that one had wilted. The predictable result of this, nevertheless, was that the ICC ended up targeting the Gaddafi regime, and no opposition figures were targeted. Here, I would also say it's important. There are a lot of allegations, and there is a lot of evidence of war crimes, crimes against humanity, and possibly genocide, but more likely ethnic cleansing by opposition forces during the civil war itself. Yet selectivity, again to quote someone, a senior staff member at the ICC, quote, has to do with the desire to illustrate to the Security Council that the ICC can be a good thing. If you start to indict those that permanent members say are wonderful and are the future of the country, then perhaps you won't demonstrate how good of a court you are. The prosecutor was interested in, quote, charging someone where the narrative makes sense. The ultimate effect of this, of course, is that the Gaddafi regime was further delegitimized, criminalized, considered evil, and the opposition forces were legitimized. Not only were they legitimized in the wider narrative, but they were very successful in using this narrative to justify their need to have a military solution to the war and ultimately to regime change, which, of course, they succeeded in. This gamble for the ICC, however, of course, in terms of getting cooperation, right, succeeding or meeting these institutional interests certainly didn't pay off. The cooperation did not come. The International Criminal Court was essentially abandoned by UN Security Council powers in Libya. And as with Darfur, no individual who has ever been indicted by the ICC has ever ended up in the dock of the court. Again, I would simply suggest that I would argue really that the effects that the ICC ultimately had, both in northern Uganda and Libya, stem from this selectivity. And that selectivity isn't random, it's not simply hyperpolitics, it's a result of this negotiation of the court's interests with the interests of the political actors which refer situations to it. So then just to conclude, again, the ICC has interests. I think we should understand it as an institution that has interests, that has agency, that wants to protect those interests, that wants to further those interests, and that these interests will really influence the decisions that it makes in terms of the situations it's willing to intervene in and the cases and targets that it's going to take up. And this is ultimately what, in my view at least, really determines what impacts the ICC will ultimately have on peace and conflict. And I think the interesting thing here, and part of what I'm working on now, is that this also, in my view, helps us explain not only other cases where the ICC has decided to intervene, but it also helps us to understand situations where the ICC isn't able to intervene. And here in particular, and just very briefly, I would mention Syria. And I think the grand narrative of why the ICC hasn't been able to intervene in Syria is because of this political deadlock at the United Nations Security Council level. And I think this is true, but the key point here is that the deadlock exists over the fact that there's no consensus as to who the ICC should ultimately target in any prosecution. And because the Security Council can't decide that one side and not another side should be targeted, there is an increasingly unlikely, it is increasingly unlikely that I think that we'll actually see the International Criminal Court intervene in Syria. And I'll leave it at that. Thank you.